coverage this evening. We're focusing extensively on that judgment by the High Court in Gauteng that the release of former President Jacob Zuma by the now former Commissioner for Correctional Services, Arthur Fraser, on medical parole around September was unlawful. The question tonight is, does the former president have enough room to maneuver out of this? We can speak to legal analyst Benedict Phiri, as well as Bloem, a former chairperson of Parliament's Correctional Services Committee. Gentlemen, my thanks to you both. Benedict, let me speak to you. It's been some hours now since we got the judgment from the court. How sound is the reasoning of the judge?
Personally, from my perspective, I think the reasoning of the judge is spot on, and I think we only have to look to his introductory preface, speaking to the fact that, Arthur Fraser's decision was really calculated, or rather would have the effect of negating the operation of a constitutional court judgment, the rule of law, and ultimately the administration of justice. And I think that sets the right context and the right tone. So personally, from my perspective, I think the judgment really sound on all the aspects that it had to address, including urgency, the locus standi of the people like the DA and the Helen Suzman Foundation, who Jacob Zuma and the Correctional Services Commissioner called busybodies, and then obviously issues around whether this decision was reviewable and whether it was legally sound. So I think on all aspects, the judge really articulating properly what the legal position is as we understand it in the country at the moment.
Stand by, Benedict. I want to bring in Bloem from COPE. Mr. Bloem, good to see you once again. Your reaction then, is this what you were expecting from the court?
Good afternoon, and good afternoon to the viewers and the panelists, you see, Tembegile, there is no shortcut in the law of this country. Shortcuts is not there. We have said from the start that this parole, medical parole, is a worked out plan of Arthur Fraser, because Arthur Fraser was a right-hand man of President Zuma. So we knew that this thing will backfire, because we have said it. You can go back what we have said as the as code, because I was in that committee. We drafted the parole, medical parole. When this Shabir Sheikh was released, we objected very strongly. But now this thing has backfired. And I can tell you, even the highest court, Zuma is having all the right to appeal, but it will not succeed, because there is no leg to stand on. If a person is terminally ill, then doctors must come and give reports and not only doctor, experts must come, not one doctor, not one expert. That is what we have said and what we have done. Now this thing, it was only decided by Fraser and his people. But Tembegile, a bigger thing, you remember when Zuma was released, President Ramaphosa welcomed this release. We want to know that who was involved in this decision. The Minister of Correctional Services, Ronald Lamula, and President Ramaphosa.
And
we
Mr.
want to know.
Just on that point, yes, because I remember at the time when there was, I think it was the City Press that reported in one of its weekend editions that the president, Cyril Ramaphosa, had given the green light for the release of the former president. The president then made a statement during the electioneering campaign. He was in Soweto, I believe, and said that he was only informed after the fact by Commissioner Fraser, who'd made this decision on his own. Do you think that as things stand, as the head of state, President Ramaphosa is likely going to have to face more questions?
We will ask these difficult questions to President Ramaphosa, because there's only one law in this country. Nobody is above the law. If there is nothing sinister in this whole thing, then the president must also come clean and show his true colors. But we have said it can begin that President Ramaphosa and the Minister of Justice and Correctional Services must answer, because this was a thing that was worked out properly.
Let me come back to you then, Benedict Phiri, and ask you about the appeal. The former president's legal team had, even after he was sentenced, and is doing so again today, argued that sending him to prison with his medical history at his advanced age would basically be a death sentence. Now, as they appeal, would the law allow possibly for a different set of medical results and assessments to be presented to support that point?
So, I think, and if we look at the judgment again, the judge really soundly putting the law to say, a medical condition is not reason to avoid incarceration, right? So, and I think that's a sound legal principle, a sound principle for the administration of justice. It's not enough to just say, I have comorbidities or I'm not well. What you need to be placed on medical parole is terminally ill. That means you're going to die within a short period of time, and there's no treatment or anything that can reverse that, or you are in such a state that, looking after you within that prison context is really not sound, right? So, and none of that was present for President Zuma. So when we look at the grounds of appeal, I think really the only reason the former president has actually put in that appeal is to suspend the operation of the order so that he's actually not sent to jail, because he's ordered to go back to jail. So we know that an appeal suspends the operation of an order, so he can stay outside of the correctional facility for as long as the appeal is being ventilated. But what we don't know, which I think maybe the DA or the Helen Suzman Foundation or AfriForum might do, is actually bring a counter application to ask the court to ensure that the order actually is operational pending the appeal process. So I'm looking forward to seeing whether that development will actually eventuate, given what the judge actually said around what is really happening here is that Arthur Fraser is really looking to circumvent a constitutional court order.
Benedict, very briefly, in a matter of seconds if you can, the judgment today said that the time that the former president has spent on medical parole will not be factored into working out how much time he's already spent. Is that common in these circumstances?
So this is quite a unique outcome or a unique set of circumstances that we have. But I think, in the ordinary course, I think we can all think of this as something that should have been taken into account in reducing the amount of time that the former president spends in prison when he goes back. But when you look at the gravity of what has happened to the effectiveness of a constitutional court order and the rule of law, I think the judge got it right to say we cannot allow a patently unlawful decision of Mr. Fraser to reduce the amount of time that Mr. Zuma is in prison. I think that's spot on. Once you get to the position that Arthur Fraser made an unlawful decision that was irrational and not supported by the facts in front of him, then you actually have to then reverse and say that Mr. Zuma must serve out the rest of the time, the 15 months in prison.
Benedict Phiri, legal analyst, regular face here on Newzroom Afrika, and Mr. Bloem, a member of COPE, the Congress of the People. My thanks to you both, gentlemen. I have a feeling we'll be chatting a lot more in the coming weeks and months about this particular story.